What's up? What's up? How we doing? It's time served. We are officially at 5K and counting. Actually, I'm thinking we're at 5.3. What's up, everybody? Are we ready? Sorry for yesterday. I had a loss of a very good friend. Just couldn't bring myself to do it. Bad news. Good news. Got about 4 days worth of clips. Don't know where to start. And I hear a OG's birthday. Samson, happy birthday, my boy. What's up? Let's have some fun. First up, Judge Stevens has a shaman in his court. Yes, a shaman in his court. Let's roll.
The 16, 17.
The short story is, Judge, we need more time to sort through that issue. Rife has been hired on one. The others need to have appointed attorneys. Langston was appointed at the jail, and he also has 2 pre-indicted cases that have not yet gone to grand jury.
Oh, there's more coming?
Yes, sir. So that's a reset, Judge.
Oh. Okay, so you're Stephen Martin?
Yes, this is Mr. Martin.
What are we doing here?
I'm going to play.
Okay.
Raise your right hand. Swear or affirm the information before you is true, incorrect. Go back to the-
Oh, God. Hey, look at this. I mean, the battery's dead. I know it's not your fault. It's just whatever can go wrong with the system is going wrong. The batteries never wear out here. You see, anything can happen is going to happen today. Weird. You know?
Yeah. I'm sorry.
Okay, Stephen. Cases, right? 22-40346 and 23-41436 are both called. Stephen, how do you pronounce your last name?
Martin.
Your middle name is what I meant.
Geis. UIC Geis.
Geis, I'll be darned. What derivation is that from? Because the U is completely
It's Geis, it's North Atlantic.
Really? North Atlantic.
North Atlantic. North Atlantic.
What's that mean?
North Atlantic is the guy left story.
He's
Which
so
one?
It's a
old.
shaman series.
Oh, so it's
Love it.
It's a shaman lifestyle.
oh,
A shaman.
but I mean, what country is that known as now?
I think that's it's transnational. Cross culture, it's transcultural.
No,
From the band.
here today, gone tomorrow.
It's sort of like that. Okay.
Okay,
All right, so you got to do it, Stevens.
these are 2 state jail felonies. All right. Does the defendant waive formal readings of these? Can we proceed? In summary, 40346 alleges that actually they both allege state jail felonies that both alleging on or about June 24th, 2022 in Jefferson County, Texas. In 40346, you committed unauthorized use of a motor vehicle, and in 41436, illegal possession of a controlled substance, namely methamphetamine. Do you understand what you were charged with in each of these cases? These are state jail felonies each, which means if convicted, you face confinement in the state jail for any term not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes,
Agreements have been reached where you would be pleading guilty and sentenced to 15 months in the state jail
Yes.
on each to run concurrent. Is that your understanding?
Yes.
If I follow this, you have no right of appeal of your cases. Do you understand?
You're dismissing this.
How do you plead in each of these state jail felonies, sir, to the allegations therein? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Guilty.
I show you what's marked as State's Exhibit 1 in each case. Did you sign those documents?
Yes, sir.
Understand them, discuss them with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into
Without objection.
without objection admitted. Among other things, this states that you are mentally competent to enter these guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it.
Yes,
You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in these cases. All of this is true. It states, so help you God. Is that so?
yes, Your Honor. So, yeah.
All right. States Exhibit 1 is made a part of the record in each case. Pre-sentence reports waived.
So moved.
Mr. Barton, I'm going to follow these agreements and find as follows. In each of these cases, you were pleading guilty voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty.
Yes, Your Honor.
There's sufficient evidence supporting your guilty pleas from States Exhibit 1 admitted in each case to find you guilty beyond a reasonable doubt.
Yes, Your
I
Honor.
now find you guilty beyond a reasonable doubt. I'm
Yes, sir.
following these agreements.
Yes, Your Honor.
You were hereby sentenced to confinement in the state jail
Yes, Your Honor.
for 15 months in each case
Yes, sir.
to run concurrently.
Yes, Your Honor.
Anything else?
No.
All right, good luck. Yes, sir. Bye-bye. Here. Hey,
Now, watch Judge Stevens' face when the guy walks out. Is it just me, or is he mocking? I don't know. I just like to dream that the judge is mocking him. Tell me what you think.
Rife, we got these other 85 cases here in Henry Green.
I'm gonna
He
I'm gonna put you on.
definitely did. He definitely did. I don't want to hear it. I don't want to hear it. He did. He mocked the shaman. All right, here we go. Next one up. Now, I have to say, I have been watching court shows for years now, court TV on Zoom, and an underrated show. And I know our own Peach, maybe a moderator, she's in there all the time, and someone who's new to my show, Daylight Disinfection, was invited me to bond court. It's basically just the Florida bond courts. They replay it, and it's just a really good time. He invited me in. I went in, and it was like I was being trolled. It was a doozy. So I'm bringing it to time served. So we're going to watch some bond court. It was a lineup for the ages. So we're going to get off a little court for a little while, and we're going to go to bond court. Let's have some fun, people. Here we go. I'm going to talk to like, can I call you here? So if I pay this
My name Marcus Darius.
Mr. Darius, sir, this is 23 MM 1979. You were arrested for trespass in an occupied structure. There is probable cause. I'm going to appoint the public defender to represent you. Is there an offer for Mr. Darius?
Yes, there is. The offer is an adjudication of guilt, credit for time served, and no return to Hertz at Orlando International.
All right.
Your Honor, can I say something?
Did you want to accept the offer?
Can
Mr. Darius?
I say something? Can I speak for myself as an authority and official?
Sure. Go ahead, sir.
Due to the fact of official ID and authority under the Real ID Act and it under the order of federal law,
Okay.
because the federal compliant ID, which is a federal ID now,
Okay.
according to the state of Florida,
Uh-huh.
I accordingly exercised myself accordingly, and I did have a warrant. And I also am Office Inspector General, which is Inspector General Criminal Investigator for CIA, and I'm also a Fed employer. Now, from my understanding, what took place, I explained to officials, I explained to a couple of authorities that's there that know I'm occupying, but also exercising myself
got
as an
it.
authority and official.
Thank you.
It was
I got it.
completely legal.
Mr. Darius, I got it. Thank you for your explanation. Thank you. So at this time, Mr. Darius, I am going to stay your bond at $500. I'm gonna order that you're not to return to the Hertz at the airport. And then I think someone from the public defender's office will probably come and talk to you about what your options are, sir.
I would want
All
to take
right.
my options right now.
Well, I don't.
So
think I'm
with
gonna
that
be able
being
to do
said, I'll take a nolo conjunte due to the fact that I'm not willing to comply with the offer I am getting, which is
Yeah.
You're gonna talk to your attorney.
Right. I'm not, I think we're gonna need to figure out what your options are and maybe resolve it on another day. Okay? Thank you.
supposed to I'm
Mr.
being held a
Darius.
little longer, or
Yes, just a little longer.
okay, no problem.
Okay, thank you, Mr. Darius.
Bond out, we do have a bond.
Okay, no problem. Slow clap, Boncourt. Oh, here we go.
No. Is this Mr. Key? Sure, that's fine. No problem. Mr. Strickland?
Yes, ma'am. My name is
All right,
Emmanuel Bartholomew Strickland.
Yes, sir. This is 23 MM1969. You were arrested for battery. There is probable cause. I'm going to appoint the public defender to represent you. You were also arrested in 23 MO386 for an open container.
Yes, ma'am.
Hold on.
I
Let me just-
apologize to interrupt.
Mr. Strickland. Let me finish telling you everything that I need to tell you, and then I'll give you an opportunity to speak.
Yes,
Okay?
ma'am.
Thank you.
I apologize.
It's okay. I also don't want you to talk to me about actual cases. If you have questions about what I'm gonna tell you, happy to answer those for you. Otherwise, I just don't want you to talk to me about your case, talk to Ms. Fritchall, but everything in this room.
Understood.
All right, so what I was saying to you is that the second case that you have is for an open container. There's probable cause in that case as well. I'm going to appoint Ms. Fritchall to represent you, her office to represent you. What did you want to tell me?
I am guilty.
He just goes, what do you want to tell me? Yeah, I'm guilty. Look at the lawyer and the freaking sheriff. I can't. Look at, you can't make this up. This is fantastic.
We'll waive his appearance, Your Honor.
Wave it.
I wasn't man.
I hear you. I hear you. Mr. Strickland, you don't have to explain. Mr. Strickland, I want to stop you. Just listen to me. You don't have to explain. I want you to answer some questions for me, though, okay?
Yes, ma'am.
So, Mr. Strickland, where are you currently staying?
Currently, I'm staying in. I just got out of the hospital yesterday, and I'm staying in on the street.
Okay. What happened to your eye?
I was shot in the face and sliced because somebody thought I was someone else. And my nurse showed me a picture. I do look just like the guy.
Oh, my God.
But yeah, I spent a month in the hospital.
All right. Well, it sounds like you need to be taking care of yourself.
Yeah, no, I do take medication. I have medication I take. And also I was going to check myself back into the hospital.
Okay. Do you know where the Orange County Courthouse is?
The Orange County Courthouse, yes, ma'am.
All right.
Know where it is.
Okay. So, Mr. Strickland, listen to me. You are not to return to 255 South Orange Avenue. Do you understand? The place where you were arrested?
Copy that, I understand that.
Okay. You're also not to possess or consume any alcohol or controlled substances without a valid prescription. Do you understand that?
Yes, ma'am.
All right. You're also not to have any contact with the security guard or the alleged victim in your case. Do you understand that?
Copy that, yes, ma'am.
All right. No, you can't possess any weapons or firearms.
I will not.
Okay. So I'm going to release you on your own recognizance at this time. All right. Get whatever medical care you need. Make sure you're at your court date. When you leave here, they're going to give you a court date. You must appear back in court on that date or you're going to get arrested.
Copy this.
All right.
You wanted that for both cases?
The sound is bad, guys, because he's not going to the microphone. It's either he's too short for the microphone or he's going in and out. So that's why I threw the closed caption in for you guys.
Did you have an offer from on the open container?
I did, it's an adjudication credit time served.
Do you want to get rid of the open container case?
Your Honor,
Container.
just
And
because
I will attend the
they're
court
connected.
date that
I think we're just gonna keep them together. I think your lawyer might have some ideas that she wants to talk with you about the case, okay? So just make sure you appear on both of those cases.
okay, they'll both be on the same court date.
They will.
All right.
Okay, thank you, sir.
Our office when you leave, because you might not get a court
And
date today.
what was the court date you
They're gonna give it to you when you leave. I don't know.
Yes, ma'am, thank you.
Thank you. Arrest you. So I'll release you on your own recognizance. No return to the scene.
I'm gonna hop to this last guy, and then we'll go back to the court. You guys get such a kick out of this one. So we're gonna go through this one. He was boring. We're gonna go to this next guy. I call this next guy Pepe La Puke.
Go back.
Just avoid it.
Look, everybody's laughing today.
Weapons or firearms, sir. All right? Thank you.
Take this.
Here comes Pepe La Puke.
Good afternoon. Your name, sir? Thank you, Mr. Douglas. This is 23 MM 135. You were arrested for resisting officer without violence. There's probable cause. I will appoint the public defender to represent you. Was there an offer for Mr. Douglas?
There was an offer by the state. The offer was a withhold of adjudication and credit for time served.
Mr. Douglas, did you wish to accept that offer, sir? Did you have an opportunity to read the plea form? Sure. Did you have an opportunity to read
Look at that smile.
the plea form that's there in front of you? Or review it with your lawyer? You did not receive the form? Okay. Do you want,
Several from, but didn't think I get that promise.
okay. Do you understand, sir, that by taking this plea today that you are going to give up your right to have a trial by a jury?
To give up my rights to have a trial by
A jury,
jury.
correct.
So meaning it will try without a jury.
It'll be over today. You're gonna enter a plea.
Okay, thank you.
You understand that?
Correct.
Okay. You also understand then you won't be able to present any evidence, witnesses, or defenses on your own behalf. So you won't get to say that the state of Florida can't prove this against you, that you didn't do it.
Oh, that's what.
If you would like to contest this case, you wouldn't enter a plea. That's what the rights on the form say. So, well, do you understand that? And you wish to give up those rights?
I mean, those rights are not a right that in my and based on my arrest because it wasn't truth, but this is what it is. So
You believe this to be in your best interest? Is that what you're saying to me?
actually, I'm not saying I didn't say that. I'm just saying, if you don't mind me expressing myself to the court.
Just don't talk about
Briefly.
the facts of the case.
No, it's just briefly. In the situation, there wasn't justice, and I'm here, and this is what the court ruling is, and this is what it is in the court. I don't have much to defend myself on without having the fair grounds from the beginning.
Okay. I just want to make sure that you understand that you don't have to resolve your case today. You could come back to court on another day and make the state of Florida prove that you're guilty.
If I come back, I still can't even prove that.
I don't know. I'm just asking you if you understand you're giving up the,
I'm gaining understanding. I'm reading, I'm learning, I'm listening.
okay,
I'm patient.
okay. Are you under the influence of any drugs, alcohol, or medication that would affect your ability to understand what we're doing today?
Clicking very sharp.
Okay. And are you currently on probation?
No, I don't. And I wish not to be.
Do you understand, if you are not a U.S. citizen, that this plea will subject you to deportation?
I've been through that already.
Okay.
So right now I'm a U.S. citizen because I've done the right thing. If you check my record,
Okay.
it's like Jesus foot bottom.
So, Mr. Douglas, that question was not personal to you either. I have to say that to everyone. Okay. So at this time, I'm going to accept your plea, withhold adjudication, sentence you to 1 day in the county jail. You've got credit for 1 day time served. You will have to pay court costs. Those will be due 1 year from today, or you need to see the clerk of the court for a payment plan. Make sure you get those paid, otherwise they will suspend your driver's license, okay?
So could you please explain clearer so I can understand clearly what you're saying at the
So as a result of today's case, you do have to pay court costs associated with the case. All right, I've given you 1 year to get those paid. All right, if you don't, they will suspend your driver's license. Okay, thank you, sir.
Thank you very much. Have a nice day. I appreciate
You
it.
too, sir.
He said, "Thank you very much, everybody." He's definitely not from around here. All right, here we go. We are gonna roll back to the clips. Back to the clips. Here we go. Judge Washington had a winner today. Oh my God, she had a winner. And then we're gonna get to Judge Webster. My Discord was lighting up with a defendant today. We have the whole clip on her. So let's get it rolling, people.
That was the reset, right, Your Honor?
You asked when I sat the end.
That's fine, Your Honor.
For the reset from this morning, Mr. Bush. I just wanted to make sure the corrections. Mr. Lorgia?
Of his recent hospitalization. And I'm not clear on whether or not he is able to resume testing, because I think that was also an issue.
Yes, there is an issue as to both of those things. He hasn't provided documentation to community corrections regarding his hospital.
Okay, so the setup here is our friend Chester Ball in the bottom. He hasn't been showing up to drop for UAs. And his claim is he was at the hospital, so the prosecutor is laying it out for Judge Washington, and she's going to say, well, what are you going to do now? So just his reaction and his oratory skills are not that, I don't even have a word for it. He's quite the Chester Ball, let's put it that way.
Hospitalization. We don't know when it ended or if he's still under doctor's care. He's missed each and every one of his reports. A formal violation has not been filed yet. However, if we don't get documentation in the next 2 days, then that is going to occur. Mr. Bell, please state your name, sir.
Oh, it's looking like he might not be connected to audio.
He's still not connected to audio. Mr. Bell, connect your audio. Can you put up the sign that says, please connect your audio? Mr. Bell? Mr. Bell? Please unmute your device, sir.
Sorry, I'm having a lot of problems with my Zoom app this morning. Apologize.
Please state your name, sir.
Chester Bell.
Mr. Bell, it appears that you have not been testing. I know you.
Before we get into the clip, do we love his nightclub / strip club general manager blazer t-shirt look? He is sporting it quite well.
You were in the hospital, but you need to provide documentation of when you were released from the hospital within the next 2 days. If not, a formal violation of your bond conditions will be filed against you. Do you understand?
Yeah, if I don't have my discharge papers, do you know who I can call? And
I can give you a call after, and we can try to figure out who to contact at the hospital.
okay.
And are you able to do some testing at this time, sir?
Well, I'm supposed to still be kind of not leaving the house, but I don't want to go to jail. I'm too sick for that.
Why are you not supposed to be leaving the house, sir?
Just because I'm supposed to take it easy and I get nauseous and stuff. And I throw up in public.
Ms. Kleeman, who needs to provide documentation of any and all of that?
Okay.
Do these particular charges involve allegations of use of any, well, here's one. This one is operating while intoxicated. What I'm gonna do is place him on a scram tether. That way he doesn't have to leave the house.
Okay.
Like a breathalyzer one.
This one would be one that, do you want a breathalyzer one or do you want one that's on your ankle?
Oh, probably the ankle.
Okay,
Because
that's,
the breathalyzer one, it goes off all night long and it wakes you up. I had to do it once.
okay.
I didn't enjoy it.
So we're gonna put you on the scram tether. Any
Okay.
objection to that, Ms. McDuffie?
No,
Sorry, Mr. Bell. God forbid you're interrupted while you're on probation with your tether. Sorry. Don't want you throwing up in public.
objection, Your Honor, although I think he would still have to leave for the download, but I'm not sure how often that is and if that's enough clearance time.
I think it's like 2 weeks,
Okay.
based on our last hearing that we had in the case. It's
So
about,
like every 2 weeks.
you have to go in, and download your tether information, sir.
Oh, I see. Okay. So just go to where the probation, where you pee at, or
Yes, where you used to get tested at, yes.
okay. Yeah, because then that will help me facilitate a ride as well.
What I'm gonna do is give you 48 hours to get on that scram tether, okay?
Okay.
And you're requesting an adjournment, correct? I was gonna adjourn that to April 17th, 2023 at 9 AM.
Thank you.
And I'm putting them on scram tether on case number 22S00951 only at this point. Are there any allegations of drug or alcohol use? Oh, yep. And the second one there is too. So scram tether company.
Oh, there's a drug charge. Yep.
Your Honor, when he reports for the scram tether, is he, I guess, should he also get the 10 panel at that time just to get one in?
All right, I'll do that. So you're just going in that one time for the drug and ETG test. We'll see what you are in baseline.
You want an EPG and panel?
Yes.
How much does the tether cost? I don't know when I get paid.
They'll keep a running tally for you. All right.
Okay.
So you should probably try to get your case resolved as quickly as possible. Either set it for trial or whatever you're gonna do. Okay?
Is it very expensive? Is that what
I
you're
think it's
inferring?
11. I think it's 11 or $13 a day.
What?
And if you decide that you could get back onto regular testing, let us know. We can go back to that too. Okay?
I can't.
Okay.
All right. Thank you.
Is that all, Your Honor?
Yes, I see you on April 17th.
Of April?
Yes. You should contact your attorney after
Oh yeah, so the doctor,
after about 1 o'clock. She should be available.
Yes,
doctor,
have my paralegal give you a call about the helping with the doctor's documentation as well, okay?
yeah, and then it's called a scram tether.
Yes, they'll know when you show up, sir.
Like he doesn't know. A scram tether? Chester.
Okay, thank you.
Wow.
You're welcome.
Good golly,
Moving
Miss
class,
Molly.
able to get it together.
Okay, so this one was sent to us by I got to remember, because I got 3 or 4 people sent it to me, and as soon as I'm going to check my email, and she sent it to me edited. This is Judge Bryant, the opposite of what you're expecting. This is what you get from her. This is why we like her. So when people say, "Oh, we just poke fun and we make fun of people and judges in the comments," this is why I enjoy court. When you get these little moments like this that capture the human element, she's wonderful. And there's 2 cases. I got one, and this was one sent to us by a subscriber. So we're gonna play this one from Judge Bryant, and then there's one right after that, and then we're gonna get into Webster. So let's roll.
I told him if he came back here one more, I told him I could maybe keep him out of jail today, Judge. But if he came back here one more time with not having anything done, especially not testing, he's definitely on his way to Wayne County. He indicated to me, he said, if I can please just get another review, he promises he's going to get everything together, Judge. I do believe him. He is showing up to court. He's still facing his responsibility despite his non-compliance. Your Honor, I'd ask the court, really, I mean, Judge, and he wasn't violated. If he was violated sooner, instead of like the 6-month review date, I would have had a chance to kind of get on top of this. But unfortunately, I really learned of his status today. So unfortunately, Your Honor, I'm only left to request an adjournment on behalf of Mr. Tremble, with the understanding that if there isn't significant progress between now and his next date, that he'd likely be facing incarceration.
I mean, why do we even go through this stuff? Why do we waste time? Why do we do this? Is it just to buy time because the person doesn't want to go to jail right at that moment?
And Judge, I have an opinion. I think a lot of times when people get into these types of situations, they consider just court and probation in itself sort of overwhelming. And you have 2 types of people, Judge, people who kind of fight or flight. And unfortunately, I think Mr. Tremble fell into the flight category and just decided that he didn't want to deal with anything. But unfortunately now he's looking at some jail time. So he just got a new job about 2 weeks ago. I know he doesn't want to lose it, Your Honor. I do believe he has incentive to comply. And he knows that, again, if he comes back with this type of report, that he can just close out the probation and do the jail. But he does not want to do that, Your Honor. He wants the court to know that he's going to lean into this and get it done and rectify some of his mishaps these last few months.
Well, this isn't his first rodeo, right? It's not. And why do I know that without having any information in front of me? Because remember, I don't know if you remember this, Mr. Murat, but Mr. Tremble has a son. And his son has his same name. And I was getting ready to lock his son up. And the son had to say, no, that's not me. That's not me. That's not me. That's my dad. Then I had to ask the son, well, what's your birthday? And then I had to confirm that the son was the son and not the dad. And I remember some time ago, when I told my daughter, this is when I was, had a hyphenated name. And I was telling my daughter, we're the only 2 people alive with this name right here, this last name. You mess up, you give me a bad name. I mess up, I give you a bad name. Mr. Tremble doesn't only have himself to think about. He has the person who he has given his exact name to. He has that person to think about as well. And I don't know. I mean, listen, I know we're all built different. We think differently. We have different values, morals. We have different, our moral compass. Some people feel like today you don't need a moral compass. I don't know. But Mr. Tremble, probation is the alternative to jail. Jail is the alternative to probation. And if the person doesn't want to do the probation, we could just go to jail. I don't want to put people in jail for, cases that probably are clearly just where a person is inflicting damage to themselves as opposed to, damage per se to the community. Now, drinking and driving, of course, can be damage to the community because if you have an accident while you drinking and driving and then somebody else is on the road and then you drinking too much or whatever, it could be catastrophic. So I mean, I guess I'll give you another chance. But Mr. Trumbull, people, they don't, some people, they have a problem like when I'm passionate or when I'm talking loud or whatever. And Mr. Trumbull, I'm a loud talker. Tell you that. I talk loud. So when I start talking low, like when I'm talking low like this right here, this means I've given up. This means this right here means I don't have any faith in what this person is saying. This right here, this voice right here is the voice of no more fight. This is the voice of defeat, which is why I refuse to speak like this in a regular, normal customary. Like I'm intentionally, I feel defeat when I'm feeling like, oh my goodness, here's another person who was already discounted at birth, now living out what people had expected of him. I feel defeated. I feel sad. This is the voice that you're hearing right now. That's this sad. Like I'm literally feel it in my upper chest area. I was telling someone the other day, we are mourning the loss of a defense attorney who clearly died, too young. But anybody under 100 is too young, in my opinion, but that's just my opinion. But he was only in his 50s and early 50s. And, I was saying how, we try to put people in a box. He was clearly a different type of person, different, he operated and functioned differently. And, we couldn't put him in a box, but people had a set thing. And if you looked at his resume, you wouldn't have expected him to be a lawyer. And so, we have to direct our own way, Mr. Trumbull. So, I mean, I'm going to give you an adjournment. And at this point, Mr. Trumbull, I want you to include me in the group of people that you have to prove wrong. I want you to include me. I want you to just go, like, get off of here and just be like, I can't believe the judge just discounted me like that. I'm going to show her. I'm going to show her that, that I can do it, that I can do this if I want to, right? If I want to do it, I can do it. And I hope you just include me in the group of people that you have to, prove wrong. I want you to prove me wrong, because right now I'm really sad. Right now I'm really feeling like, goodness gracious. Like, what can I do or say to make him act up? Like, I'm a passionate person, Mr. Trumbull, and normally I would just be on here. Everybody who's on here knows I would be on here like, Mr. Trumbull, come on, get yourself together. Come on. That's how I would be doing. Mr. Trumbull, I'm kind of wore out a little bit, but I want you to prove me wrong for your sake, my sake, and your.
Have you ever seen her like this? Ever. Ever. Never. I watch her every day.
Your son's sake.
Okay.
He has your same name, Mr. Trumbull. He out here getting in trouble.
Right. You're right, Your Honor. Okay.
All right.
I appreciate it. Thank you very much, Your Honor.
You're welcome. Mr. Murrah, how much time does he need? Well, I only put him on probation, even though, yeah, he's only been on probation for
18.
I think I sentenced him back in September. And I put him on for 24 months. So he has a while, but he's off to a real slow start. So September 26th, so let's see. Well, let's just bring him in at the halfway point. Let's just bring him in like September of this year and see where he is. And I'm whoops. I'm hoping that maybe he'll be finished and he can get discharged early after I discounted him. So let's see, September. His halfway point is after the 22nd. So what about we do him? Let's do October 5th, Thursday, October 5th, early October. I told you all about this morning that Ms. Knight saying you could sit.
However, he also cannot represent himself. He that
All right.
Ballard, I think, is correct in his assessment there that no counsel will be suitable for Mr. Winburn in his eyes. However, he also cannot represent himself. He has a jury trial was begun several years ago. He caused a mistrial after numerous warnings from the judge and instruction. He is incapable of conforming himself to the rules necessary to conduct a jury trial. A counsel representing him will be necessary. As to the relationship between Mr. Ballard and Mr. Winburn, I have nothing to add, except that yes, we have been through everyone in our county, and this is the third out-of-county public defender's office that have attempted to represent him in various levels of success.
Your Honor, may I respond?
Here we go.
What is it that you need to say, Mr. Winburn? I just wanted to just draw the court's attention to, in one of my motions, in the motion to dismiss, that you mentioned that you did receive and docketed. There is, I'd like to correct this, Mr. Dobie, that it's not that I don't have the right. I have a constitutional right of self-representation, and the previous order suspending that doesn't operate as a lifelong judicial edict that can constitutionally stand. I have a constitutional and common law right and statutory right of self-representation, and it's a misstatement of facts and of the historical record that I actually caused the mistrial. If the court looks at page 39 of my motion to dismiss, that's the motion that was filed February 22nd. I specifically, very detailed, outlined all the facts. The prosecutor's office prompted a mistrial and claimed falsely that I was incompetent to represent myself. And that's why I'm arguing at page 39 that the double jeopardy clause bars a retrial. And I'm asking the court to visit all my motions, allow me self-representation, look at the facts. I've been held, Your Honor, for 7 years as a pretrial detainee without a trial, right? And I've been treated worse than the Guantanamo Bay prisoners in Gitmo, Your Honor. This is in the United States of America. This is not Cuba, and this is not communist China. But I've been treated worse, and they think the prosecutor. Yes.
Mr. Winburn?
Yes, Your Honor.
The motion on the floor right now is the motion to withdraw as counsel. As I said previously, we're not going into any of the other motions.
Right.
It sounds like
Yes,
you
Your
have
Honor,
other
but
legal issues that you need to.
The square that's talking, I see somebody that's asking, is right underneath Judge Slay. He's in a table. So there's no point if I blow it up or not because you can't see him anyway. It's more audio. So it's the guy underneath. He's constantly in her court. I actually had a clip of his the first time, and what they're always saying is that he doesn't want any representation, but he's not competent to represent himself. And this is the fight they have every time he appears.
deal with
Yeah,
outside of what is on the docket for today. So what will be
Right,
addressed
but
is the,
Okay, yeah,
Mr.
but the
Winburn,
Okay.
is the motion to withdraw counsel, which will be granted. I'll contact Ms. Hightower from our NDIP liaison to try to find another counsel to stand by for you. These motions will be adjourned out to May 15th. Mr. Adobe, I would expect that I have responses to the motions.
Your Honor, you're asking me to respond to the motions that he has filed himself? Okay.
Yes.
And in addition to that, Mr. Adobe, whenever the new counsel is appointed, because it looks like we've been through anywhere from 7 to 11 different attorneys at this point, I'd like you to take the opportunity to sit down and do kind of an accounting of discovery. I understand it's customary that other counsel will give to the next. What I'm concerned about is we've had so many attorneys, maybe not everything has gotten to Mr. Ballard at this point. I'd like
Yes,
you
sir.
to have just an accounting and double check to make sure that he has, he or she next will have everything that they need to.
Your Honor, thank you.
And obviously, Your Honor, I can't speak to us having everything. We will immediately comply with, once we're notified that there is new counsel, we will send it. I will cite for the court, we've had discussions with appellate attorneys in regards to this to see where they can go with this case. That was kind of the direction we were going in hopes of getting an appellate attorney that can take up Mr. Winborn's issue to self-representation. Obviously, we are no longer pursuing that, given the order today.
Mr. Whitburn, we will see you back on May 15th. Thank you, sir.
Thank you, Your Honor.
Your Honor, thank you, Your Honor.
Before I get into the main event here, I've been scouring the internet for you guys, literally for you. I've been scouring for you because I don't want to be boring and just keep playing court clips and keep playing court clips. So I had time this weekend and I found this very small channel called Law Chronicles. He's an attorney. He plays court clips. Some of them are not funny. They have no ending. I don't know what the point of it is, but if you keep looking, you find doozies. And I got into a rabbit hole, and his name is Attorney Anderson. I haven't done my research on him yet, but I got a picture of him. He narrates, and he even puts softcore porn music in the back of the court clips. It is hysterical. This one is, the clip that I'm going to play is a clip of his clip in court making a citizen's arrest. He's making a citizen's arrest, and I'm not going to tell you the outcome, but it is fantastic. And then we will get into our main event. This is a 5K treat for you. I thank you. 300 in the room, mods. We made it. All the hard work. I love all of you. Let's rock and roll to the court clips. Oh boy, you are going to love this guy. Oh my God. That's him. I'm laughing already. Okay, let's roll.
I'll go through point by point and show you the important parts of what I did and then explain why I did it. I'd like to give you a little bit of background so you understand why it is they do what they do. When you go through family law, custody, and visitation proceedings, they intentionally deny you equal access to your children. They do this so then they can charge you the most in child support. One of the main factors in calculating child support is the amount of time you have with your.
I'm gonna say, the guy knows his craft. He's very knowledgeable. Okay? I mean, we got a Lurch thing going on here. Howard Stern meets Lurch. Don't know what's going on. Love the voice. Just wait until he starts playing the music. But when I tell you, the guy is interesting and he knows what he's talking about. So that's also why I introduced him to the channel. And I also reached out to him. I want to get him on the show. Yes, I did.
Child. So they have a vested interest here in taking your children from you so they can jack up your child support to the maximum amount. And they use a software program in California called a DissoMaster, and it actually calculates everybody's income, any deductions you have, any tax write-offs, etc., etc. In California, if my memory serves me correctly, they take like up to 49% of your income, which doesn't leave you as a single father the ability to live yourself or to even ever have another life, another child, another relationship. You're now a slave. And the other thing they do is they let these cases hang for a while. They let your child support build up, and then they come after you for what's called arrears. And then they charge interest on those arrears. So even if you would pay all your back child support, they would then hit you with another bill for the interest. I've seen this go on for 20 plus years, and it absolutely devastates parents, single fathers usually, and puts them into financial ruin. I would also like to mention that any cases that go to the county district attorney via welfare system in California, it's Welfare and Institutions Code, Section 11375. They call it reimbursement. So what happens is the federal government sends those public assistance welfare dollars to each state. The state then, through the counties, disperses that money to the individual parents. So under the Welfare and Institutions Code and Title IV of the United States Code, the Social Security Act, the state's obligated to go after the absent parent to recover or get reimbursement for that child support or the public assistance monies that are paid out. Now here's the kicker. Any of those reimbursement monies that are collected by the state keeps. They do not send the money back to the federal government. So the state has a vested interest on any of this money that they collect via the reimbursement process. They don't send it back to the federal government, they keep it. So it's in their best interest to separate you from your children so that they can make the most amount of money. It's a scam that's destroying the fabric of our society. There are so many children growing up without fathers in their lives that they turn to crime, they turn to gangs as they get older in life. They have no social structure or structure of what a father's supposed to be in their life. They have children themselves, and they have no sense of responsibility to that child. So now that generation of children is growing up without fathers. If you look back over time now, we're about 60 years into fatherless children. Look at what it's done to our society. Now that's also good for the government because a lot of these kids turn into criminals. They're roaming the street in gangs with guns, committing crimes. Mr. Falkowski out in the hall before court proceedings, and I told him, look, I don't want to have to do what I'm about to do. You know, I told him, hey, look, you know, I'm going to have to hammer on you, and, you know, it's not really what I want to do. And he just kind of giggled, and he looked at me, and he's like, yeah, I can hold my own. Well, you be the judge of that. Did he hold his own? Let's watch some video, shall we?
Mr. Falkowski, did you want to take up Mr. Alexander's matter? Mr. Alexander, case number 375134. Oh, hang on just a second, Mr. Falkowski. Mr. Alexander has asked for a video of the proceedings.
Excuse me, are you attempting to serve me something, sir? So when the video starts out, you see him walk over and he tries serving me some documents. Well, that's not appropriate service under the Code of Civil Procedure that governs service of documents.
Hang on just a second, Mr. Falkowski. Mr. Alexander has asked for a video of the proceedings.
Now here's something I really don't understand. The judge tells Mr. Falkowski to hold on. Mr. Alexander requested a videotape copy of the proceedings. So where's the lady that's running the videotape machine?
For the record, I gave Mr. Alexander some advance sheets.
So, of course, I object for the record, and then he starts to give an explanation. Well, I came across these, and I'm thinking, I don't care what you came across. I'm the moving party. I filed the moving papers to bring us to court. I get to speak first. That's how the rules are written.
Your Honor, I would object at this time.
Well, just additional authority that came to my attention after I filed my response. I basically am in court.
So once again, I have to voice my objection.
Objection, Your Honor. I'm the moving party, and I'd like to address the court before Mr. Polkowski says another word. And based on situations and circumstances...
And then we have Bailiff Tom. Bailiff Tom steps in with his clipboard and his stipulation, and he says, hey, you got to sign this. And I say, I'm not signing it. And then he's like, whoa, we can't hear your case. Well, like, he's the one that makes that determination? Who the heck is this guy? He's a bailiff.
Let's sign this first. I'm sorry, sir, I can't do that. Well, I can't hear the case, sir.
And then Mr. Polkowski comes in, and even though I'm somewhat procedurally out of order, well, no, you're definitely procedurally out of order, so shut up.
Although procedurally I may be somewhat out of order,
And then you hear Mr. Polkowski come in and say that one of the rights Mr. Alexander is alleging that he's violating is his right to counsel, and he wants to hold the matter over until Friday.
I would ask that it be set over until Friday, since one of the rights that Mr. Alexander is stating that I'm violating is his right to counsel on the underlying contempt action, and if it was continued until Friday, a public defender would be present, could advise him on that issue. I think that's the first issue we should take up, is whether or not he's representing himself, or whether or not he wants a public defender appointed.
Okay, those of you that think Mr. Alexander wants a public defender, please raise your hand.
Mr. Alexander, you know I can't proceed without a stipulation. Do you wish me to send this over to the presiding judge?
No, I don't want you to send this over to the presiding judge. I want to just spin this in your face. Hold on.
Your Honor, if I may briefly address the court.
Okay, it will have to be brief, Mr. Alexander.
Briefly, Your Honor.
Okay, it'll have to be brief because I have 4 trials scheduled and I'm just too damn busy for justice.
I do have 4 trials.
Pursuant to documents filed in the United States District Court this day, Fresno County Superior Court judges en banc, including all, the full court, are named expect adverse parties in a federal class action lawsuit. Thus, it would be inappropriate for any Fresno County Superior Court judge to hear this case.
So I name the full court en banc. That means all the judges inclusively. And in doing so, it creates a conflict of interest, so nobody can hear the case. So then comes the fun part. Now it's time to place Mr. Polkowski under citizen's arrest. So I start with the 3 elements necessary to perform a citizen's arrest under California law, Penal Code Section 837.
Equally, it is my intent, pursuant to my authority under California Penal Code Section 837, place Mr. Polkowski under citizen's arrest.
So immediately the judge hears the magic words, bing, 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 authority, citizen's arrest. She's all, what? What are the charges?
On what basis, sir?
So then I cite the charges. I start with Penal Code Section 166, which is contempt. If you bring proceedings before the court that are false or fraudulent, that's contempt. If you lie in front of the court and file false documents, that's contempt. So the other 2 charges were Penal Code Section 422.6 and 422.7, which is discrimination against a qualified individual with a disability or discriminating against a handicapped person. In this case, those statutes are threats, intimidation, coercion, etc.
Violation of Penal Code Section 166 as well as 422.6, 422.7.
And then you can see I look to my right, I look right at Bailiff Tom, and I tell him, hey, take my prisoner into custody. You can cite him out pursuant to Penal Code Section 849. That's your discretion.
At this point in time, I am additionally requesting that a peace officer of the state of California takes that individual who I now deliver into custody. You may cite him out pursuant to Penal Code Section 849, sub B1. That's your discretion.
Now, people, this is the fun part. You gotta look at the judge. You gotta look at her body language. You gotta look at Mr. Folkowski. Look at his body language. At first, it's kind of funny because it catches him off guard, but then he realizes, oh shit, all the elements have just been hit. I've been placed under arrest. You see him reach in his back pocket, pull out his wallet and his keys, and he says, give these to my wife. I'm under arrest.
Additionally, Your Honor, I would leave the court a copy momentarily, my personal file copy of said petition under Federal Rules of Civil Procedure Rule 27, filed this day with the federal court.
Now there's a cool tool. Federal Rules of Civil Procedure Rule 27. It allows you to take depositions of people without filing a lawsuit. So it's like a form of advanced discovery. Now, did I think it was going to go anywhere? No. Did I think it was going to stir the pot and create a bunch of shit? Absolutely.
Going over and serving the presiding judge and bank.
Tom, if you could hand me a copy of that Mr. Alexander has.
Now, I don't disrespect these people, but I don't give away courtesy copies of crap for nothing, especially to a judge. That's why I serve the presiding judge and bank the full court. Then it's on him to make the copies. And then you can hear me tell the judge, and I'd like to have it back, Your Honor. Give it back.
I would like to have this back, Your Honor, and while the matter is under consideration, I would like to depart from the courtroom, proceed with my associates across the street to serve the presiding judge. Also, my associate here today has a duplicate copy for which we would like to serve on Mr. Folkowski. Therefore, I would request that these documents, whatever they are, be returned to Mr. Folkowski, and when it's determined how we proceed, such appropriate service would then take place. I believe, Your Honor, that with Mr. Folkowski, everyone in the District Attorney's Office, pursuant to this Federal Rules of Civil Procedure Rule 27 petition, as well as every judge in the Fresno County court system appearing in bank, has a personal interest in the outcome of this matter, and therefore be inappropriate and create a conflict of interest.
Now, I never stick all my eggs in one basket. So that's why I say, in the alternative, let's do this. Plan B.
In the event I'm wrong, I would like minimum of 2 days to prepare a 170.1A6C challenge for cause against each and every judge in the Fresno County Superior Court system.
Now, there's a provision in California Code of Civil Procedures 170.1A6C. It's called a challenge for cause. If you file a challenge for cause against a judge, they have to answer that. If you then disagree with their answer, it has to get sent to another judge in a neighboring county for adjudication. So there's many different ways you can stop these people in their tracks. And as you'll hear, it stops Mr. Folkowski in his tracks. He'd like to set the matter over for a few more days.
I'd go along with this request to continue the case for a couple of days until Friday. I think that's what should be done.
I think that's what should be done. Did he learn that in law school? And then he goes to the Rule 27 petition, and he wants to know, has this been filed? Am I in here somewhere? And then the judge inquires and states, oh, it's been lodged with the federal court. And then I go through and explain to him a Rule 27 petition, how it's filed in the federal court, that it originally goes to a magistrate, etc., etc. And what you got to understand is I'm dealing with a state judge. Actually, she's a commissioner. She's not even a real judge. That's why they want a stipulation so she can hear the case. You have to agree to it. But these state folks don't know anything about federal law. So when I'd shove federal law up their ass, they had no idea what to do.
I haven't had enough. Has this actually been filed? It was.
My copy indicates that it has been lodged with the clerk of the U.S. District Court.
Now, there's a pretty picture of absolute judicial confidence. Look at the judge. She's camped out with her arm holding up her head, just confused. I don't know what's going on. I don't.
I had to troll you guys. Come on. It's my 5K surprise. You really... Come on. He is a doof. Oh my God, he's a doof. Oh, here we go. Now he has a soundtrack on his channel. I'm going to show you the I'm gonna let you listen to the audio, and then we're going to Webster. Come on, guys. Really? Really? Oh, good Lord. Good Lord, some things should not be on the internet. Okay, ready? Here we go. Here is his music, people. We're ready? Music videos. Alright, that's enough Weird Al meets Howard Stern meets Lurch. Let's roll to Webster. Here we go, people. Judge Webster's in the house. Let's do it. Let's rock and roll. Boy, oh boy, this was crazy. Let's have some fun with Judge Webster. This lady was off her rocker.
But I did usage.
We're gonna start it.
So did forward.
Thank you.
Okay, let me get it right at the top for us.
And I do have the signed statement.
Okay, so hold on. Sorry, guys. Here we go. Okay, so what we have here is Judge Webster. Let me just crop it for you because we had it. All right, here we go. We got Judge Webster in the house. All right, and this defendant, Megan Barnett, she's at a treatment center now. When she is appearing, and she's got a whole ton of violations, and throughout, I didn't want to through her whole docket, but in the beginning she was munching on food, so I'll preface it with that. She was eating in court, and Webster really doesn't call people out right away, so she lets it kind of build. So I want to thank My Crazy Life once again for introducing me to this clip. So now I'm going to let it play. I spliced it together because they go and come back. Let's roll. Just listen to what happened with this woman. Off her rocker.
That the CSO from Sedgwick County did forward with that information. Again, the defendant did sign it. Also on March 3rd, the defendant's UA result in Sedgwick County was positive for cocaine, and her BAT result was again positive for alcohol with a 0.048 reading. Again, she did sign an admission and acknowledge the positive result.
Okay. All right, so does she wish an evidentiary hearing, Ms. Patterson, Mr. Patterson? At this time, I'm denying the request for a continuance. This has gone on long enough. We need to proceed.
Judge, I would ask to talk to my client, and I believe the counselor is present, so I'll probably call the counselor at the end of this hearing, but if I could talk to my client first, Judge.
Certainly. We can have a breakout room, and when you're doing that, I'll probably take up someone else. I'll do that now, Judge. Thank you, Savannah. All right, on the record in 2022, TR 3407, State of Kansas versus Terrell Barrett Jr. State appearing by
Amber Norris for the state, Your Honor.
Terry Barrett, are you present? I think alias summons was issued to Mr. Barrett. Driving while suspended second, no insurance, speeding 92 and a 75. His first traffic appearance was supposed to be on 118. He failed to appear, so Mr. Regier for the state filed an alias summons for today. Looks like, I'm not sure if we had service on him or not. Did we, Savannah? So is
Your
that-
Honor, I'm showing served by certified mail.
Are there any bondsmen? Mr. Jackson failed to appear November 30th, 2022. He was on bond at that time. Bond forfeiture bench warrant was issued. Ms. Norris, you may call your first witness.
Your Honor, state would call Christine Donovan.
Ms. Donovan, do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Please proceed, Ms. Norris.
Please state your name and occupation for the record.
Christine Donovan. I'm a court service officer in Butler County.
And how long have you been supervising Miss Barnett?
Since she was placed on probation on September 20th of 2021.
And have you previously done a requested revocation for her case?
Yes, this is a second request for revocation. She was reinstated on probation previously. Sorry, I'm looking for that date. That was on July 11th of 2022. She was ordered to serve
Okay.
on July 11th of 2022. She was ordered to serve 48 hours in the Butler County Jail, and after serving that time, placed back on probation. Probation was extended for 12 months.
Okay, and then you said that was in July of 2022?
Yes,
Okay, and you've been supervising her since that date?
yes.
And what sort of issues were you having with Miss Barnett that caused you to request another revocation?
The defendant had violations with her scram.
Objection, Your Honor. Hearsay objection.
Response, Ms. Norris?
Your Honor, I wasn't actually going to have her go into the specifics. But I do know that there is no one from Scram that's necessarily present here today regarding specifics on violations. But I do believe that Ms. Donovan can speak to the fact that she was on that as part of probation, et cetera.
Ms. Donovan, what signed information or releases do you have from the defendant with the scram?
Your Honor, they have been, while she was on scram, they had been communicating with me regularly regarding non-compliance issues.
Judge, can't object. I don't think there's any release that's going to get around a hearsay objection and evidentiary objection.
Well, Mr. Patterson, they are required to give reports to the court.
I agree,
Ms.
Judge.
Donovan is my agent.
And Judge, again, I don't know how you get around hearsay objections unless there's a witness present to testify, or if there's an affidavit that would allow this proceed on a probation violation.
Ms. Donovan, what kind of reports do you have from the scram people?
Your Honor, they forwarded reports regarding the tampers and the alcohol violations. They are graphs regarding those violations and how they occurred. Again, something they would probably be able to attest to.
And these are documents that you receive and keep as a official records custodian in this file?
Yes.
Well, I would say that these records are part of the official record and she's custodian of them. And as such, they should be an exception to the hearsay, Mr.
I
President.
would ask for further argument, Judge.
Go ahead.
Judge, and I guess as a way of voir dire, I would suggest that if Ms. Donovan was to testify, she would testify that these are not records that she keeps in her regular course of business, specifically the actual SCRAM documentation, the SCRAM reports, that these are reports that are kept in the regular course of business from the 13th Judicial Electronic Monitoring, that Ms. Donovan merely receives copies, but that's not a hearsay workaround without having somebody to establish that those records were kept in the regular course of business, that the foundation is laid for them, and then they would come in. It's almost hearsay upon hearsay at this point. So without the hearsay being cured, Judge, I don't believe there's any way around it.
Well, let me just ask Ms. Norris or Ms. Donovan, can you get somebody from the SCRAM on here in a reasonable period of time?
Your Honor, I have someone in my office contacting Kelsey at the monitoring office to see whether or not she would be available at this time.
All right, so we'll come back to that. Ms. Donovan, other than the SCRAM, are you able to proceed, Ms. Norris, and try to do, I think you're kind of multitasking there. Are you able to proceed with your questioning of Ms. Donovan, skipping over that, but coming back if you get the information you're looking for?
Yes, Your Honor, I believe that we have some additional information. She was placed back on probation on January 7th, or I'm sorry, July 11th of 2022, Ms. Donovan. And when was she placed on the SCRAM and why?
SCRAM was a condition of her bond when she was released from custody after being arrested on the first warrant. And when she appeared for the warrant to show cause hearing on that first warrant, and the court reinstated her, the court required that SCRAM remain a condition of probation.
Okay, and so she's on the SCRAM as a basically continuation of her bond, and then you had written up an addendum to your original warrant, which the bulk of which talks quite a bit about SCRAM violations. Are there any other violations in there that are not related necessarily to the SCRAM unit in your original warrant?
The initial warrant is related to SCRAM and alcohol violations.
Okay, and did she make any admissions to you about alcohol violations?
At what point?
While she's being supervised by you since July of 2022.
Yes.
And when were those?
I'm gonna have to review my notes here. Her file is very extensive, as there has been a lot of activity.
Okay. And basically, I'm asking for specifically when she has made admissions and either personally to you or signed admissions that you have documentation of.
Sure.
Thanks. And Your Honor, while she is reviewing that, it's my understanding that Ms. Moore is getting on from electronic monitoring. And go ahead, Christine.
All right, so we can come back to the, yeah, go ahead.
Okay, well, as to the signed admissions, those are the ones we reviewed initially. Those would have been on February 6th and March 3rd of this year, 2023. Those
Or
are
she
the,
made admissions of alcohol use.
yes.
Okay.
February 6th and March what?
February 6th and March 3rd.
Okay, she said on both those dates and in writing that she had used alcohol.
Yes.
Okay, go ahead. Thank you, Ms. Norris.
And in addition to that, I have 3 Wichita Police Department cases indicating.
Objection, hearsay, Your Honor.
Are you objecting to the Wichita Police Department cases or to what she
Yes.
has not yet said?
I do not object to the February 6th or the March 3rd, since those are admissions directly by Ms. Barnett. Anything that would be contained within a Wichita Police Department report would be hearsay. Object to hearsay.
Okay, but you're not objecting to the fact that she has Wichita PD cases.
That she
wouldn't be
has
true.
pending matters, I don't think is relevant either so much because they're pending. So I guess it's the relevancy is not there either.
Well, let's let Ms. Norris follow up on that. Maybe she can connect that.
And Christine, just, I guess maybe explain a little bit without going into information that's in the police reports, but you're mentioning police reports, why?
They involve the defendant. And they regarded contact with the police and her that indicated she was under the influence.
Objection, Your Honor, hearsay.
Sustained.
Okay, now, has she been reporting to you since she was placed back on probation with you since in July of 2022?
Yes.
And how often and how is she reporting?
13, you were in Jackson.
She has reported by FaceTime, telephone. She has reported in person in Sedgwick County. And thus, that is why I said we are communicating quite frequently with the CSO there.
Okay.
She has reported very frequently because there has been so much going on with her case. So it's not only scheduled appointments, but just continuous contact for various reasons.
Okay. And did the defendant inform you of her contact with law enforcement, or did you find that out some other way?
Objection, Your Honor. It's not an allegation contained within this hearing. It'd be irrelevant to the warrant to show cause.
Overruled.
Ms. Donovan?
On some of the occasions, she did notify me. On some of them, I learned through other ways.
Okay. And your biggest concerns regarding this defendant and what you think is most appropriate at this time for her?
Well, this is a second inpatient treatment program during her probation term since I've been supervising her. And I have worked with her extensively, trying to help her seek out services and get well. And she has gotten into treatment again the second time after all of these things have occurred, but was somewhat resistant initially to following through.
So she's currently in treatment now?
Yes.
And you're saying that she went into treatment after this March 3rd admission of drug and alcohol usage?
Yes, and I will say that she actually had a bed date prior and did not go when scheduled. So as I said, I've been trying to work with her. However, it has been somewhat of a struggle because she had been resistant. She did finally get into inpatient, which is, in my judgment, where she needs to be. But one thing we didn't mention was that after a prior violation last year, a modification order was done for her to go into inpatient treatment back on October 31st of 2022 due to alcohol violations and scram violations at that time. She did go into treatment and complete a program. She completed 2 weeks of inpatient and was discharged to outpatient, and then struggled on outpatient and basically quit attending. And thus she's in inpatient now. But it has been constant alcohol violations, concerns about her well-being. I have had to call and request a welfare check. Other people have called to request as well.
Objection, hearsay.
All right, so sustained to other people, but overruled to Ms. Donovan's 2 calls to, did I understand you made in the calls to welfare check?
Yes, Your Honor. The defendant, I understand, had been engaging in mental health treatment. I was notified by Hunter Health that she had been attending mental health treatment as well prior to going into inpatient treatment. However, that has also been a big concern throughout this time. Like I said, I feel like she is probably where she needs to be right now, given all of the totality of what's occurred. And again, I'm limited to tell you because of the hearsay rule, but there has been a lot.
Okay. Thank you, Ms. Donovan. I don't think I have any further questions, but Mr. Patterson may have some follow-up for you.
Mr. Patterson, cross-examination?
No questions for this witness, Your Honor.
All right, any further evidence, Ms. Norris?
Yes, Your Honor, we would be calling Kelsey Moore with electronic monitoring.
Please raise your right hand, Ms. Moore. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Please proceed.
Please state your name and occupation for the record.
Kelsey Moore. I'm an electronic monitoring officer for the 13th District.
And Ms. Moore, are you familiar with Megan Barnett?
I am.
And can you explain to the court why you're familiar with her?
She was placed on our program on a scram unit back in May of 22.
Okay, and is she still on a unit, or when did she stop being on a unit?
Her end date was December 27th of 22.
Okay, and do you recall why that's the end date?
There was a motion filed. She was having some issues with her ankles and the bracelet.
Like some
health issues.
Okay, okay, as opposed to, again, electronic issues or whatever with the bracelet.
Right.
Okay, and while you were supervising her from basically May to December, did she have violations of the SCRAM program? Was she compliant?
No, she had multiple violations.
Okay, and like a couple violations?
I can. We've got 5 alcohol consumption events and 27 tamper events. Some of the tamper events were tampers with alcohol. Because SCRAM, if there's a tamper involved and alcohol, they categorize it as a tamper because they will not confirm an alcohol consumption with a tamper.
Okay, so okay, that's quite a few violations and tamper events. And what can tamper events include?
So tamper is anything placed between the skin and the unit itself. Because when the unit takes a reading, it's taking IR voltage, it's taking temperature, and it's taking alcohol. So if something's placed between the unit and the skin, the temperature changes, the IR voltage changes, and the device recognizes a tamper.
Okay.
Lady, I'm going to stop you right there. It is not appropriate or acceptable for the lady sitting next to the defendant to be slipping her notes during this hearing. Unless she is co-counsel, attorney at law to Mr. Patterson, she needs to quit leading this witness and giving her notes. Now I see there are 2 more people present. Who are all these people sitting there with this defendant, Mr. Patterson?
Well, Judge, I believe they're all personnel of the treatment facility. And in fact, the one next to her is her therapist, who will be the next witness or the first witness I call.
Well, then it's inappropriate for them to be slipping notes back and forth. Maybe we need to have these witnesses sequestered if they're going to keep slipping her.
Judge, I think she will sit back and far enough that she's blurred out and wait to be called.
All right. Well, I don't want any more of this slipping notes back and forth. That's inappropriate. She wouldn't be allowed to sit at council table and do that if this were a live hearing, and she's not going to be allowed to do it at a Zoom hearing either. All right, go ahead, ladies, if you remember where you
Thank you, Your Honor. So you had said we were just talking about what included a tamper event, and then you said and how many alcohol events?
There were 5 confirmed consumption events. And I think I was tallying it. There was close to 20 of the tampers. 20 out of the 27 tampers were tampers with alcohol.
Okay. And from July 11, 22 to when you said that she was off of this SCRAM program in late December, were those in that time frame?
There was 1 tamper May of 22. The rest occurred after September 17th of 22.
Okay. Okay. So basically everything, most of the ones that you have and that we've been talking about, they all happened after July of 22 when she was placed back on probation.
Correct.
And what do you mostly do when you get this information? Do you contact the defendants, the probation officer, all of the above? How do you kind of deal with these tamper and alcohol events?
We do both. With the alcohol events, they go straight to the CSOs. With the tampers, depending on if it's just a tamper or if it's a tamper with alcohol, on the tampers, typically the first just tamper with no alcohol will warn the client to watch their clothing, make sure nothing's sliding between the unit and their bracelet. And then after that, we start issuing violations for any subsequent tampers after the first one that gets a warning. Now the tampers with alcohol, with her specifically, just they were day after day. I just ran a lump sum report and sent it to Miss Donovan.
Okay. And when defendants are in programs, like say they're in treatment or something like that, do you guys still have the unit on them or no?
Yeah, so she was in an inpatient treatment somewhere. I can't remember which facility she was in, and she had called because the bracelet was irritating her. So I went out to the treatment facility and swapped at ankles and did a fit adjustment for her.
Okay, so and the only place that you generally remove that is when they're like in jail.
Sometimes, if they're gonna only be in jail for a couple days, we just leave it on. The jail lets them wear it. So if they're only going in for like a dip, we'll just leave it on during that time. The only time I'll take it off is with a judge's order, because the judge orders it on, a judge has to order it off.
Okay. Thank you, Ms. Moore. I don't think I have any further questions, but Mr. Patterson may have some follow-up, okay?
Mr. Patterson, cross-examination.
Thank you, Judge. Ms. Moore, I wanted to see if I could get, first of all, a little bit more information on this tamper with alcohol versus just an alcohol. What's the difference in that?
So if there's just an alcohol, that means that the temperature stays steady right where the normal for the client. So when they're first placed on, we take what's called baseline readings. So it can tell where the IR voltage is supposed to be. And you expect that to be even keeled, because once it's on the client, it shouldn't vary. There shouldn't be anything moving that bracelet. And so just in an alcohol event, there's no tamper, the temperature is the same, the IR voltage is steady, and there's alcohol detected. If there's a tamper with alcohol, then you're seeing that IR voltage kind of bounce around. The temperature's changed in one direction or the other. So it recognizes it as a tamper, but it's still getting alcohol readings during that time as well.
Now, you stated that the monitor was removed on December 27th because of a health issue that had developed. Is that correct?
Yeah, she was having, I think, sores on her leg from the unit.
Okay. And I'm looking at a report that indicates a substantial number of these incidents happened in December of 2022. Is that correct?
I've got 8 in December of 2022.
December of 2022.
Yeah, I've got 8, one of them being just alcohol, and then 1, 2, 3, 4, 5, 6 being tampers with alcohol, and then 1 just being a tamper.
Okay. And the tampers, could that have had anything to do with her health issue she was having that was leading up to the time to take it off?
In a conversation with her, and she was placing, I believe, a cloth between the bracelet and her ankle when she would drink, is what she had said.
And you stated that you then report these to the probation office. Is that correct?
Yes.
Do you also have a conversation with Miss Barnett anytime these occur?
We had talked to her a few times. Sometimes it wasn't the easiest getting a hold of her. We would call and she wouldn't answer, so we would text her and have her call us back. We had talked to her, but if Christine had already talked to her, then I didn't talk to her as well.
So do you talk to the clients and try and verify from them whether these are actual alcohol events or if something else is going on?
So the company will ask if the company wants to know what the client's doing during that time, then I tell them. Then I'll ask the client, hey, what were you doing during this time, and report back to the company. On these specific ones, they confirmed it just due to the data that had been collected off of the bracelet. They didn't need to know what she was doing at that time.
So she never was asked to confirm any of these.
I know I'd had conversations with her about them. I never asked her if they were true or not, I don't think.
Okay. No other questions?
Ms. Moore, you said you don't know if you ever asked her if they were true or not, but yet earlier you testified that she told you when she was drinking, she would leave a cloth between her ankle and her bracelet. How do you
Right.
justify both those answers combined?
So I talked to her about the tamper, but I did not talk to her about the alcohol events he was asking about.
I see. Thank you. Ms. Norris, any redirect?
No, Your Honor, thank you.
Just
All right.
based upon the court's question, I guess I have one additional. The tamper, it sounds like, was a towel between the monitor and her ankle. Is that correct?
Yeah, I believe that's what she'd stated, that she was putting that in between because there's the strap and then there's the unit part, and the unit part is what you can't put anything between. You can put stuff around the strap, but just not the unit itself.
And was that in December that you were calling her and asking about that?
I would have to look at her reports. There was quite a few.
Let me ask it a different way. Maybe this will help. Was she saying that she was using that towel between herself and the monitor because of the health issues she had going on?
No, not at that time. She had started to wrap the strap due to her sores. And I told her that was fine as long as it didn't get into the unit itself.
Okay. No other questions.
Let me ask you a question real quick, guys. So, Baby Time came up to me and said, I have a lot of homework due because she had practice and all this other stuff. So I said, well, what do you do for me? Because I'm a math teacher and, you know, I know it's like the back of my hand. So she said, I don't know. So she'll let the dog out. Whatever. So I said, make me a smoothie. Am I a bad parent because I wanted a smoothie and I didn't want to get up and then I'm going to do her math homework? What do you think? Listen, it's your fault because I'm with you guys.
But again, she said she was doing it to when she was drinking.
Right, because I had questions as far as the alcohol readings that were coming in on the tampers.
Okay. All right. Anything from anyone else on this witness?
No, Your Honor.
No, Your Honor, thank you.
Any further evidence for the state, Ms. Norris?
No, Your Honor, thank you.
Okay. Any evidence for the defense, Mr. Patterson?
Your Honor, I would first call the therapist at Miracle's house, which I did not get her name, so I'd ask that she identify herself first.
Okay.
My name is Megan Pinkley and I'm an LAC here.
How do you spell those names, please?
MEGAN. Pinkley, PINKLEY.
And what was your title again?
I'm an LAC.
Which means?
Licensed Addictions Counselor.
Okay. And you're with which organization?
Miracles.
Miracles. Okay, thank you. Go ahead, Mr. Patterson.
Judge, if I could ask that she be sworn in.
Please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
And is there some way we can keep both you and the defendant on the screen? There we go.
Can you see this?
Thank you. Go ahead.
Okay.
And again, Ms. Pinkley, could you state your name for the record?
Megan Pinkley.
And you stated that you are a licensed alcohol counselor at Miracles, is that correct?
Licensed Addictions Counselor at Miracles.
Very good, thank you. And then also, I wanted to find out, how long have you been at Miracles?
I started July 4th, 2022.
And prior to that, what did you do?
I was a behavioral health tech at a local hospital.
Now, as a part of your work and tell me, first of all, what is Miracles?
It's a residential treatment facility for women dealing with substance abuse.
And as a part of your work at Miracles, are you familiar with Megan Barnett?
I am.
And can you tell us when she would have entered into Miracles?
She checked in on March 13th, 2023.
And was that following any other type of treatment?
I do not believe so.
When she first arrived, was there an intake done?
So she arrived 5 days prior initially, but due to being under the influence, she went to detox for 5 days and then came straight here, and then the intake was complete.
Okay. And through the intake, what did you determine any course of treatment would be?
She would continue with level 3.3, which is inpatient treatment for a period of 28 days. And then afterwards, we would look at outpatient treatment as a follow-up recommendation.
When would the 28 days be finished?
Monday, April 10th.
And up to this time on March 27, could you give us a summary of her treatment and how she's done?
Sure. So she has done well. She met with me. We meet weekly, at least. We've established treatment plans and tasks for each goal that she has been working on through our program. She's attended all the groups that she has been asked to attend. She's been attentive to court dates and things like that. So far, she has done everything that we have asked her to do for treatment.
And I know this is a tough question, but I'm going to ask it anyway. Do you have a prognosis on her?
I won't give you like a firm answer because it's substance abuse, right? We never know. But what I can say is that when she did enter, she was resistant, not super excited to be here, but she has opened up to the idea that there may actually be issues that she has that she needs to address in order to protect her sobriety moving forward.
And going forward with the time that she is at Miracles, what's the plan for her?
I'm going to recommend that she attends level 1 outpatient treatment with the potential for level 2 if she seems to struggle. I'm also recommending that when she leaves here, she immediately gets involved with sober living. So continuing with her mental health, getting a mental health evaluation and following through with those recommendations, following through with outpatient recommendations, and as well as sober living. I think that will be the best scenario for her when she exits our program.
And what is sober living?
We haven't decided exactly where she's going to go, but it's going to be either a sober living facility or like an Oxford house, something like that. We haven't really narrowed down exactly, what she would prefer.
You mentioned that there would be a mental health evaluation. Has she done anything with that to get an evaluation yet?
She has not. She has been very verbal about wanting to get one while she's here. However, with our staffing issues, we are not able to facilitate getting them in some cases to ComCare to get that mental health evaluation. But her and I have been in communication about making sure that we have that settled and scheduled for as soon as she gets out of here, so she can go and get that done and follow through with what's recommended.
Now, you stated that it could be level 1 or level 2 outpatient. Could you tell us the difference in those two?
I'm going to start recommending with level 1, which is 2 groups a week and a meeting with her counselor. However, if she has trouble, she's going to be encouraged to verbalize that. And then if we need to bump her up to more intensive, which is going to be 3 groups a week and a counselor, that's an option that she has.
And how long are those usually in length?
Usually it's a 12-week session, so 3 months, depending on her ability and attendance.
No other questions, Your Honor.
Ms. Norris?
Patterson's usually on his on his game, right? Webster likes Patterson. He's always good. For some reason, he was off today, right? I think this girl got to everybody. She pissed everybody off today. She's just got that face you want to smack. She looks like Meg Griffin.
I just wanted to confirm, I wasn't sure if I quite got the date. When did she come into the program there at Miracles?
Let me confirm. I'm almost positive it's March 13th. Yeah, she checked in on March 13th.
Okay. Nothing further, Your Honor. Thank you.
I guess, Judge, one more question based upon that. You stated that she came in on the 13th. Did that include the 5 days or not?
It does not. That does not count towards the 28-day program. The 5 days of detox prior was on her own.
Which would have been, my math is right, March 8th.
Correct.
Okay, nothing further. Thank you.
You said she'd been attentive to court dates. How many court dates has she had? Because I think this is the first one she's had scheduled with me since March 13th.
She has another court date, something with Sedgwick County, and she had an original date. I believe it was was it Tuesday?
In lieu of that, Your Honor, I have not said anything to Ms. Barnett, would lead her to believe that a sanction is not something that's probably going to happen. I mean, sanctions as a result of probation violations are something that helps them maybe get better on probation. So, Judge, I would tell a court that whatever sanction the court would deem appropriate, I know that Ms. Barnett would accept the court's ruling, but we just asked the court to allow her to complete Miracles prior to that time. Thank you.
Ms. Donovan, what do you recommend?
Your Honor, I would concur with Mr. Patterson. I feel like Ms. Barnett is on the right path right now. However, she's still in a structured living environment. Having another court hearing to assess her progress might be beneficial for her, might be another incentive or reason to stay on the right track. As I said, we worked with her previously. She's been back to court. She's been to inpatient. She's been an outpatient, and now she's back in court again. So she has continued to struggle. And I just think that anything we could do to help her at this point for accountability might be a good thing. Hopefully she will get into sober living upon release and will continue on that path. But again, I would agree.
Thank you all. Ms. Barnett was found driving on June 21st, 2022 on a public roadway in Butler County, Kansas, over twice the legal limit of 0.08, specifically at 0.172 BAC. She has been on supervised bond, followed by probation ever since June 26, 2022. She was in violation during her bond. She was sentenced September 20th, 2021 for 6 months. Her probation, she was found in violation of her probation yet less than a year later, July 2022. Her probation was revoked but reinstated after she served, I believe it was a few days, maybe in jail, I don't recall, but as a sanction. That was July. By October, she was still using, but rather than coming in on a full-blown revocation, she consented to do treatment for continued use. That didn't happen right away. Somewhere along the way, she tried a treatment, but apparently that didn't work out. And we come back here on this revocation, her second revocation, since she was sentenced. She's been on electronic monitoring a good portion of that time as well. And she either can't or won't quit using. And I suspect, as folks have said, it's got to be an addiction. The way she's consuming and violating. Yeah, she served 48 hours from the July 11th, and then she went back onto probation and violated her scram by October. And it was only removed, the scram was only removed in December because of problems with her leg. Who knows how the results would have been from December to now, but I don't think anyone in earshot of this hearing or participating in it can fail to see the strong addiction this woman has to alcohol. And I noticed throughout this hearing, her probation officer has emphasized how much she needs treatment, how many there have been welfare checks made on her, because she's obviously got at least Miss Donovan, and it hinted at maybe a lot more concern that she's going to do herself in with alcohol consumption. 5 alcohol uses, 27 tampers with alcohol between July and December, 5 months. Miss Donovan said, no, I believe it was Miss Moore mentioned that day after day they had issues. She even admitted that when she drank, she would deliberately put the cloth between her ankle and her bracelet, trying to apparently and obviously distort the results. When she even went into this treatment, Ms. Pinkley said she was resistant.
She's incognito now.
She arrived and needed 5 days of detox before she could start the treatment 14 days ago. But she did make it through detox, and she has apparently made it 14 days into treatment, which seems to be a tremendous step since that day in 2021 that she was arrested. Finally, maybe a breakthrough. Finally. And then she's got something going on in Wichita, Sedgwick County that we don't know about, but it's obviously something enough that she's been going back to court for. You know, normally when somebody violates their probation to this condition, it's serve your time. But in this case, it's obviously an addiction, a very deep addiction. And again, if she weren't starting to show some concern and effort, I might still say, serve your time. But because she is now trying, and maybe now for the first time in years, she's got a real chance at getting a grip on this addiction and being able to contribute to society and not be a law violator. And I know 2 weeks, that may be too optimistic to make all these conclusions, but it is a huge step. So for this reason, I am going to follow Ms. Norris's recommendation that we reinstate her probation for 12 months. But this is conditioned upon you, Ms. Barnett, completing successfully every step, every inch, every direction that you receive at Miracle House. Because it is a miracle that I'm not just outright revoking your probation. It is a miracle that you've got a chance at straightening your life out and kicking this horrible addiction that's had such a grip on you that it's controlled your life and potentially killed people with a DUI if you've been in the wrong minute of your addiction and driving. There will be some jail sanctions, but I'm going to also take Mr. Patterson and Ms. Donovan and I think Ms. Pinkley's advice and hold off on further orders until you complete Miracles. And that includes not only their inpatient treatment, but their outpatient as well. So I want you to completely graduate from inpatient. And then I want you to completely graduate from outpatient, following whichever one they want you to start with. Now, they like to start with, it sounds like least restrictive and work their way up to most restrictive. I'm probably just the personality type. I'd say, let's start with the most restrictive and work back, but that's their call to make. You really open up to those people at Miracles. You really.
So it's sooner than later, so that we just keep, so that Ms. Barnett keeps it in
Sure.
mind that we have
Okay.
a hearing coming up.
That is a good point. We do, as you said, keep your feet to the fire. So what are you recommending,
45 to 60 days from now.
Ms. Donovan? Are you okay with that? Does that make sense?
Yes, Your Honor. I think that's appropriate.
Okay, so then Savannah, that puts it on you to find me a hearing date about 45 days out. 45 to 60, no more than 60, no less than 45. There's a job for you.
Sorry, I can do June 5th.
Okay, that's not too far from Ms. Norris's recommendations either, so. June 5th at 9 a.m.
Thank you,
Got
Judge.
that marked down.
Work for everyone?
On July 11th of 2022, she was ordered to serve 48 hours in the Butler County Jail, and after serving that time, placed back on probation. Probation was extended for 12
Here we
months.
go. Now.
Okay, and then you said that was in July
got
of
a lot people in
2022?
here. Give me
Yes.
1 second.
Okay. And you've been supervising her since that date?
Got a lot of people in the room. I'm gonna keep it rolling. I am going to show you the Mike Page debacle today. If it's in the thumbnail, I'm gonna play it. We've got 373 in the room. We're rocking and rolling. We're only at 2.5 hours. We're at 5K. I owe it to you for trolling you tonight. So let's go, Mr. Page. Where art thou? Where is the mic page? Oh no! Did I do it? Did I download the mic page? Yeah, I downloaded the mic page. Hold on, hold on.
So who is on the phone ending in 0?
All right, so while I'm uploading Mike Page, I'll give you this one from Thurston. Just listen to the guy on the phone. Enjoy.
Maybe so. What's your name?
Andrew Otterer.
Mr. Otterer, this is Judge Wilcox. I just dismissed your case because
Yeah.
you weren't here. Where were you at 9
Ma'am,
o'clock?
I was on hold. I was trying to call. I'm extremely sick, laying in bed.
So
I've been
on
calling since
hold with
8:30
the
this
court?
morning.
Where were you on hold?
With the with the district court. They kept saying your call is really important. I've been sitting on the phone for an hour.
Okay, since 8:30?
Yes.
Okay. All right, and Mr. Dix apparently appeared at one place, but was told to come here and did not appear here. So what I'm gonna do, Mr. Auditor, is withdraw that order to dismiss, and we're gonna reset your case. This is case 23-47. And we'll reset it to another day. I see, well, let me see here. Back up here, 23.
Excuse me, I'm sorry.
Well, you're proving your sickness there. Actually, we did on February 27th, both parties were present and Mr. Dix was given notice, but he has not reappeared here. I understand that maybe he was appeared by Zoom. I'm looking to my clerk. He appeared by Zoom in another courtroom and was told to come here or in person. Okay, he hasn't, and it's been 45 minutes since we started. So,
Okay, here we go with Mike Page. I'm gonna show it. This is a good one too. Somebody sent me this. This is fantastic. This is a good one. This is a 5K celebration. Pay attention to this one for 5K. Here we go, and then we're on to Mike Page, and then we'll call it a night. But listen to this. This is great, guys. Just give me 1 second. Upload it. You guys are gonna love this one.
Township. You did by engaging in patterns. What was that? I mean, what? You can't be serious. You can't be serious. I apologize. Well, your apology isn't accepted. You're a moron. You can't do that. For gosh sakes, I'm having a court hearing here. No kidding. Yeah, it looks like it. Yeah, you got a nice attitude. I just don't feel too well today. Oh, that's too bad. All right, before I was so rudely interrupted.
All right, let's get into Mike Page.
Item R, and this is Ms. John Rowe.
Thank you, Mayor. I'll try and keep this brief. I won't belabor all the details. I'm sure most of you remember Mr. Guest's presentation.
Okay, this one gets real ugly real quick. Got crying and yelling and screaming. Just another day for the office for Mike Page. Let's roll.
It's kind of choppy.
Sorry about that.
I'm not sure how I can hear you. Oh, there.
I can see if I can get that on Wi-Fi here. Maybe they'll.
Now you're frozen.
I'm trying to log into the Wi-Fi here to see if it's any better. I'm at the Kent County.
23-58851. Caitlin Alfman and Jalen Thomas, both are here. Mr. Thomas in person. His attorney John Danion's on Zoom, and Ms. Alfman's on Zoom. And this is the date and time set for hearing of Ms. Alfman's motion regarding custody. She filed this matter and filed a motion at the same time. In the motion, it said that the parties agreed to the entry of an order. But then the response was filed, and I get the feeling that may not be the case. Both of you raise your right hands. Do you swear or affirm any testimony given this cause to be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir.
Yes.
All right. And ma'am, you filed a custody motion. Why don't you explain to me what you're requesting and why?
I'm requesting joint custody just to be civil. So I have equal rights to my children as does he.
Okay. First question I have is, when you filled out the paperwork, oh, there you go. You wrote your name and then you said in care of Melanie Fleas. What's that mean?
I'm having my mail delivered to my mom.
Oh, okay. All right, and what do you want to say in support of your motion then? Two children, I guess. One is 1 and one's 5 months old?
No, our son is 18 months and our
And my
daughter
daughter's
is 6 months.
So
6 months. 18 months and 6 months.
18 months is 1. And 6 months, okay, so it's been a month since this was filed anyway. All right, and so I'm getting her testimony first, and then I'll let your attorney speak at your, all right? So, ma'am, what's been the custodial arrangement up until now?
I left the kids with him for stability because that's where they've been since they were born. I didn't want to uproot them and, change their whole daily routine and their whole living situation. So I could get my things together and take care of the things that I needed to because I couldn't there. I didn't have the right transportation. Jalen lives there with his grandmother and takes care of her and his disabled uncle as well as our children. So leaving and taking me to work is very hard because he has to leave, leave his grandmother there alone and hope that, nothing happens. So that's why I'm doing this to help myself so I can help them.
All right, so you left the kids with him. When was that?
About a month ago.
Oh. So for the 18 months of Giovanni's life, did the 3 of you live together?
Yes.
All right, and then Leilani came along and it was the 4 of you for about 4 months?
Yeah.
4 or 5? Okay. And so you raised the children together up until a month ago?
Yeah.
Okay. And for whatever reason, you're no longer together, but you want to have the court enter an order where you split time with the children on a somewhat equal basis?
Yeah.
And you want
As often as I can because I'm about to start working tomorrow. So as often as I can.
okay. And you want to have equal rights of having input into major decisions regarding usually medical education, things like that?
Yeah.
All right. And you're basing that on the fact that you were an involved parent, I guess,
yeah.
for the duration of the kids' lives?
Yeah.
All right. And so I got a couple different addresses here for you. I don't know. Are they confidential or not?
I'm
they be confidential?
not sure.
All right, I guess it is, but so how far away do you live? How many hours or minutes?
It's about an hour drive, maybe a little over an hour.
Okay. And so Mr. Thomas here, he was equally as involved in raising the children as you were for the time you were together?
Yes.
All right, so you both read stories, put the child to bed, gave baths, cooked meals,
Yeah.
the whole thing? Okay, all right. All right, and then Mr. Daniel, you filed a response to the motion. And in the response, under 7 and 8, you disagreed with an order of joint physical and joint legal custody. What were the reasons for disagreeing?
Thank you very much, Your Honor. In speaking with my client, he has very serious concerns about whether or not Ms. Hoffman has a stable or satisfactory environment. He's told me that since these children were born, it's been him that's been the primary caregiver for these young children. The same types of questions you were asking a few minutes ago of Ms. Alfman. He does take care also of his elderly grandmother, and he's more than capable of doing this. He wants to have his children living with him. That's the way it's always been. He doesn't know, even if the plaintiff were to exercise parenting time, he doesn't know where that would even take place. I don't think she's really shared with him her current address or who's in the house with her, or that it would even be a safe place to take these kids overnight. He's willing to give her some, limited parenting time until maybe a friend of the court could dive deeper and do an investigation. But at this point, he wants to maintain primary physical custody and primary legal custody. My client indicates that Ms. Alfman has been inconsistent and he can't rely on her, even if there was an emergency. He doesn't want to keep her from her kids, but he just wants something in place first, more stable, before he would agree to more of an expanded schedule. There's also, unfortunately, a history of domestic violence between the parties. And Ms. Alfman, the police report from 2020, where she had held a knife to her own throat, and so threatened self-harm. It's all in the report. We have my client has copies with him there today if you wanted to see it. But it's something that just rises to the level that we think a little bit of caution is warranted here before we proceed to a full schedule. And an hour and a half away for a young child like that is going to be very difficult for transportation. I don't even know if she has reliable transportation at this point.
I do, actually.
All right, let him finish, man.
So, yeah, I mean, I can ask my client some more questions. They're also under oath, but I think for the safety and stability of these children, he's just asking for a little bit of caution on a temporary basis to award him primary physical and primary legal custody. She picked up and left about a month and a half ago. More than happy to leave the children with my client, and now she wants to get back into a 50-50 arrangement. We just want to be very careful, Your Honor.
All right, Mr. Daniel, do you have any questions for Ms. Alfman at this point? She kind of testified and I asked her some questions.
No follow-up questions, Your Honor.
All right, if you have some questions for your client, then you can go ahead.
Thank you. Mr. Thomas, can you hear me?
Yes.
Okay, so what are your concerns about a 50-50 arrangement at this point in time?
At this, like we spoke on the phone, I'm not in no way, shape, or form trying to keep her kids from her or anything of that sort. Right now, I don't feel comfortable as far as 50-50 because until she gets her personal matters outside of whether they're legal, mental, whatever, taken care of. I want the best for my children. Nothing else matters to me.
You were the primary caregiver, you told me, right, for these children?
Yeah, I am. The children are with me.
During the relationship, did you share those responsibilities, or was it still primarily you?
As far in what regard, sir?
When you were together living with Miss Alfman, how did it break down in terms of who provided for the children and took care of them?
We were on government assistance all together.
But in terms of the daily types of activities for the children, feeding, bathing, reading them bedtime stories, taking care.
It was mutual. Like, she participated. I'm not saying that she wouldn't participate or she wasn't taking care of the kids. Like,
okay. What do you think in terms of any parenting time for Miss Alfman, if the court were to issue a temporary order?
Whatever she can do, whatever she can do.
How about overnights though?
Right now, and she knows why. I'm not comfortable with that.
Do you want to share anything else with the court about that? What your feelings are there or what your rationale is?
Because she has legal matters that need to be taken care of, and I don't.
Are you aware of any outstanding warrants for Miss Alfman?
I would, yes.
Out of what county?
Lake.
So if she were to get picked up with your children with her, that'd be a concern.
I
wouldn't it?
wouldn't be picking my children up, but I would have somebody pick them up
Ma'am,
for me.
Ma'am, I want you to be quiet for now. I'll give you a chance to respond. Just sit tight, all right?
So, Mr. Thomas, are you asking the court at this time to at least issue a temporary order for you to have sole physical custody and sole legal custody of the children?
As far as like, I'm not asking for sole legal. Like we can do joint legal. I want her to be a part of her kids. As far as physical,
I got something.
if the courts can come in and put some order, would that, and until like, I don't know how to explain it. I will do joint legal, but full physical.
right.
That's
Just
for the time being.
Just so you understand, joint legal means that she would have an equal say in any medical care for the kids or education and things like that.
Like I said, sir, I'm not trying to take her from her children or keep her like.
Right.
Them
I'm
are
just
her
asking,
kids too.
realistically, how would she be involved in those types of things, given her current situation, to be able to take the kids to the doctor or the dentist or appointments like that?
I mean, I've been the one, the kids are with me. I'm the one who takes the kids to the doctor's appointment.
Right. But if you give her joint legal, then she would have that right also immediately to be able, and that's fine if that's what you want, but I'm just saying, how would that work logistically if there's transportation issues or stability issues with Ms. Alfman?
That's something I can answer, sir, because I just don't, I don't want her to feel like I'm trying to take the kids from her.
Okay. If she were to visit the children, how do you propose that would work? Would she just come to where you are?
Yeah, she doesn't have to, I don't have to be there. My grandmother is perfectly capable of being there. Like, and I'm not saying she can't, like, we can't meet somewhere and she like, I just don't feel comfortable with her situation right now.
Okay, thank you very much.
Thank you.
Ma'am, do you have any questions for Mr. Thomas?
Nope, not at all.
All right, so, sir, what's the legal matter she's facing? I mean, could be a traffic ticket, it could be homicide, I don't know.
No, it's not.
I mean, what's going on that
It's
causes
a-
you concern?
Homicide.
She has an outstanding warrant and has
Big range.
I know, but for what offense or what offense?
Yeah,
another domestic violence.
right.
And that's out of Lake County?
Yes.
The victim of the domestic violence?
No.
No,
Who's the alleged victim of that?
Matia Smith.
yeah,
Matia Smith.
And they're related somehow?
No, they were living together.
Oh. That's pending in what county, Lake?
Yes.
watch this.
And she's been charged or what?
Yeah. Last I knew.
Do you have any proof that there's an outstanding warrant?
I don't know what, like She,
I mean, I agree. If she had a warrant, that would be concerning, but.
I don't-
If you have this, just your knowledge, how would you know?
just my knowledge of her living with me for the past,
Also, she's had it for that long?
since it was, I don't want to be wrong here, but it was at least a month before my son was born.
Did you became aware somehow of an outstanding warrant?
No, that the situation happened, and
So that person was living with both of you?
I was in jail here in Waco County.
Oh, were you in jail?
I have an explosives charge and a controlled substance charge.
Explosives and controlled substance?
Yes, my stepfather did some things to my mother, and I've been dealing with that for a very long time, and I took the situation into my own hands.
You've got an explosive charge and a controlled substance charge, and she has an assault charge.
Thank you.
And you're wanting her to not have unsupervised parenting time or even overnights because.
Thank you.
No,
She got in a fight 6 months ago?
no, that is not what I'm saying, sir.
You said you wanted sole physical custody and you didn't want her to have any overnights.
I'm not saying she can't have overnight, sir, until her legal matters. I had to be a man and step up and take care of everything that before I was able to.
So are you on probation or parole?
No, I completed that with improvement, like my
When were your charges? When did those come from?
2020.
You also said mental health. What's going on there?
As far as, and since we're gonna sit here and do this,
That's what it comes down to. It's unfortunate sometimes.
I don't.
It is unfortunate.
I gotta decide these cases based on evidence.
I'm not-
What's in the best interest of children.
I don't want to take her from her kids. I never said she couldn't get them overnight, but as a man,
50-50 is fine. Go ahead.
as of right now, I'm not comfortable with that until her legal matters are taken care of.
Okay.
May
You
I
also mentioned
may I say
mental
something?
health.
Just one thing.
Hold on.
Just yesterday, I have messages that she threatened to harm herself.
No. Mm-mm. No. 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 No.
I have text messages right here. My phone is right here.
Just because I said I wanted to disappear and I wanted to be gone does not mean that. And our children also have other siblings that they need to have a relationship with, and they don't even know each other.
But the fact of the matter is, I'm just gonna pull them up.
My ex is letting me take my kids overnight plenty of times out of state. There's no
How
reason that
long?
my
How
children
long?
are
Can
unsafe
I ask her
in
a
my
question,
care.
please? Can I ask her a question, please?
Well, you got an attorney.
Mr. Danon, how long did it take for you and Ryan to come to an agreement before you seen the kids?
I'm sorry, what are you asking?
I want to ask her how long before when her other custody case happened, how long was it before she was allowed to take the kids overnight?
Oh, okay.
That was because we had a CPS case open and there was other things going on that had nothing to do with Ryan. I would have been able to take them overnight sooner if CPS was not involved.
All right, well, tell me about that. You opened the door. What was going on with
Yeah, I
CPS?
did open the door. I did. I really did open the door. So in March of 2020, when Jalen got caught with a bomb and methamphetamine in my vehicle, CPS was at my house the next morning and my child got taken from my home. And a month prior to that, a friend of mine, so she says, had beat my son because she was on drugs. And yes, I was using drugs as well. I am clean right now, thank the Lord. And I have every mean to be around my first older two children My ex sees what I am accomplishing. I am taking my medicine every day for my depression and my anxiety. I have a job and I start tomorrow. I have support, a lot of great support, because Jalen couldn't support me mentally like I needed him to. So I needed to remove myself before my kids seen me hurt myself because of how depressed I was. But since I have left and I've been getting my things together, slowly but surely, I've been doing so much better.
I haven't listened.
Did they say what she said?
I'm sorry, my reception's cutting in and out.
Do you want me to read it?
Well, I don't know. Did she say she wanted to disappear, be gone, or she wanted to kill herself?
I never said, I'm throwing in the towel. I give up on everything, my life included. No one want to see me happy, so I'll give everyone what they want. I'll be the deadbeat ass mom. I won't show up to court tomorrow, so you can badmouth me. Do whatever you
You're
gotta do.
doing.
Jason. I'm not badmouthing you by any means. I'm really not.
There's no reason you should feel uncomfortable that I can't take our kids overnight when they have other siblings that have just
Where
enough
would they
of
be?
a right to them.
You live in a you're staying in a 2-bedroom home.
Okay, and there's
How many
people that
people
can
live in that?
leave. There's people that
many
can
people
leave
live
for
in
a
that
night
home?
or two so that my kids
How
can be
many
here
people live in that
comfortably.
home? How many animals live in that home?
And how many people live at your home? Our kids don't even have their own room there.
We have a room together.
Yeah, together. Livy and
So, ma'am,
Owen
do you
can go
have-
spend the night at their
ma'am-
grandmother. They
Ma'am, do you
can
have
have
your own room?
Owen and Olivia's room.
No.
Ma'am, stop talking. Do you have your own room at the house you live in now?
Yes.
And so you have your own room that the kids share with you at your house?
Yes.
So she has the same situation.
It's not the same situation.
Yes, it is.
No, it's not.
How many people live at your house?
Me, my grandma, Carl, my uncle that is disabled that I help take care of, and my mother recently moved in to help me.
How many bedrooms do you have?
I live in a home. My family has property next to PV storage, 10 acres. My grandmother's house was a 2-bedroom, and then my grandfather added 3 more bedrooms onto it.
All right. Ma'am, you live in what, a 2-bedroom?
It's a 3-bedroom.
3-bedroom? And you have your own
Yeah.
room with room for these 2 kids?
What was that?
You have your own room that has room for these 2 kids as well as you?
Yes.
What about your other 2 kids? They're there as well?
Yes. Yes, they have a bunk bed.
So your bedroom would have 5 people sleeping in it?
No, my bedroom would not have 5 people sleeping in it.
You, the 2 other
Me,
kids, and these 2 kids.
me and
would
my
be
2
5.
youngest kids. Me and my 2 youngest kids.
Where are the 2
And then my
oldest
2
kids?
older kids have their own room.
Oh, so who lives in the 3rd bedroom then?
My mom and my youngest brother,
And who else lives there? Who's the owner of the house?
Logan, and he sleeps in the recliner and has since he moved in.
So you would be sharing the room with you and Ryan.
No,
And
I did
the
not
kids.
say Ryan.
Right, but Ryan lives there.
Ryan sleeps on
Okay.
the couch as well as Logan sleeps in the living room.
So you got 11 people living there?
No.
If these 2 kids were there, it'd be 9 without them and
No.
11 with them?
Okay, I'm not trying to have them live with me, but to stay the weekend, to have a relationship with their siblings, I'm only talking about a weekend. Every
you're
once
not
in a
talking about
while
50?
when I can do it.
Not 50-50.
I thought you
The
were talking
other
about
people
50-50.
I have a job. I can't take them for a week at a time.
Okay, I appreciate that. I thought in your motion you were requesting 50-50, and I thought that's what you said when you testified.
That's what I'm trying to do, but it can't be 50-50 when I have a job. He don't have a job. So he has all this free time.
Okay, you all right with her having weekends, every other weekend?
Yeah.
All right, well, that's a lot easier.
Thank you.
So it sounds like you're both in agreement for order indicating that Mr. Thomas would have temporary physical custody.
sleeping there tomorrow.
You'd share joint legal custody. And mom would have, Ms. Elfman would have reasonable parenting time. That would be every other weekend. There's a holiday schedule in there. No, it does offer 50-50 in the summer, but it sounds like at this point, you're really only able to do the every other weekend, ma'am. Is that right?
Yeah, because I have to work to pay off my warrants and stuff because I don't have anybody that can financially help me, so I have to do it myself.
All right. Okay, now that'd be a temporary order. In these types of cases, the judge will set a pretrial down the road, and you'll have the opportunity to bring up any issues that have arisen. And if you want to make changes at that point, then the judge would set up for a hearing either with herself or then back again with me to make that determination. The only other thing I wanted to ask about is in the complaint that you filed, ma'am, it says that that Mr. Thomas had acknowledged paternity by signing an affidavit of parentage for both kids. That's correct?
Yes.
All right, because Mr. Daniel brought that up in the response that we needed an order of affiliation, but if there's an affidavit, we wouldn't need that order, right, Mr. Daniel?
Correct, Your Honor. I haven't seen that, and I'd have to try to see if we can get a copy from Lansing or just have them do a new one.
Well, I mean.
I'm on both of both of the birth certificates.
Yeah, if it's not an issue, I don't need.
It's not an issue.
Yeah, he brought it up in the response.
No, I understand.
Asking. Because if it is an issue, I want to make sure the case gets reclassified as a DP, but we can't go determining paternity in a DC case, which is what's been filed. If they already took care of that, I'm not gonna open that can of worms.
Okay.
Them children are mine. I want to state that for the record. Like,
I don't think, it was just in the response, it's the only reason I brought it. All right, so I'll do that order. The reasonable parenting time policy has some other administrative provisions in it that I'd expect you guys to follow, but other than that, you should be all set for today. Okay?
Thank you very much, Your Honor.
All right, we should be all set then. Let's see. So ma'am, you only work every other weekend, so the weekends won't be a problem?
No,
You work every weekend?
no, I'm not working every weekend.
Oh,
she hasn't started yet, sir.
all right. So that you're
But now
on the
that I
right
know what our custody agreement is, I'll make sure to let my boss know that I can't work every weekend.
Just wanted you to be aware that the rotation, and hopefully it works out. If it doesn't, then you guys can modify it if you need to, but the rotation would be that this past weekend would have been the non-custodial parent weekend, so it would have been your weekend. So then your next weekend would be the 7th, 8th, and 9th of April. We also get every Wednesday from 5 to 8. I know there's a little bit of a distance here, and maybe you have to work, I don't know, but the opportunity to have those 3 hours is in there as well. Okay, again, if you have to work Wednesdays but not Tuesdays, I would hope you guys can work together and just do it on a different day.
And that, so I want to put that in for the record too, like, that's communication. I just hope that we can come to an agreement after this.
Oh, we're going to.
You'll have an order to fall back on, so.
Okay.
Paige just cut it
The,
off. He just cut it off.
The plane's ready, Ron.
All right, guys. It's been great. The stream is picking up every night. I appreciate everything. I appreciate you. Another 5K treat tomorrow. I will be same bad time, same bad channel, 7:30 Eastern time. Thank you, everybody. Go watch Kitchen Court Cases if you want to watch someone cook. You want to watch a little Judge Kim, and you want to wind down, and you want to hang out with me, and the moderators in this room will be over there. So go hang out with my girl Kitch. Thank you. My new moderator, Heather Smoochie. No, slow clap. See you later, guys.